Okay, next we have our organizer, Katerina Sideri, and the title of her talk is Patenting Diagnostics and the Future of Personalized Medicine, Private Property and the Romance of the Public Domain.
So I'm going to talk about the US position on diagnostics, but let me just say some preliminaries. So patents on diagnostic uses are often referred to as disease gene patents, and they typically cover all known methods of testing for a gene mutation. So the invention is based on statistical observation of a genetic difference and a phenotypic difference, the occurrence of a disease, and the patent claims any method of testing for that genetic difference. So this is a typical way a method claim is drafted, a method for diagnosing a predisposition for disease X in a human subject, which comprises obtaining a sample from a patient, determining the presence of a biomarker, and the presence of biomarker in the sample indicates a predisposition for disease X. So improvements in diagnostic testing, they are essential in bringing about the promise of personalized medicine, the right drug for the right patient at the right time. But the US Supreme Court, in a series of decisions, said that diagnostic methods are ineligible subject matter. So what is the logic behind making some research products eligible subject matter? And is there any logic? And what are the consequences of extending legal rights to one type of scientific research product and not to another? These are the two questions that we'll explore today. So let's begin with Mayo, decided in 2012, and to look at the language that was used by the court closely, because it's very interesting and very important to look at the language that is used. So the court said that that was a patent which it was a standard diagnostic method which administering a drug, measuring the level of a metabolite, knowing based on the result whether to increase or decrease. So the physician would determine whether to increase or decrease the drug's dosage. So the court said this is ineligible subject matter because it's preempting a law of nature. So the court said that an application that they follow established case law, so laws of nature, natural phenomena, abstract ideas are not patentable subject matter, but an application of the law of nature to a known structure or process may deserve patent protection. And why we need that? Because the claim must limit its reach to a particular inventive application of the law, the court said. And why? Because otherwise those laws and principles because these laws and principles, that the court said, are the basic tools of scientific and technological work. So we will inhibit future innovation, and the invention forecloses more future invention than the underlying discovery could reasonably justify. So the court said that we arrive at the conclusion that the processes at issue are not patent eligible, while eliminating any temptation to depart from case law precedent. So they insisted that there is established case law. So this test has been used in a number of subsequent cases. Alice was a computer case, but it's strengthened Prometheus by holding that abstract inventions, such as an algorithm, were not made patentable by implementing them on a computer. They said we need something more. So, and the court in a very important decision, the Supreme Court in 2016 denied Sequinum's petition for certiorari. So they said that the Alice and Mayo remain, and the discovery now in question, we heard about this a little bit yesterday, was a very important invention, cell-free fetal DNA. So it was a non-invasive technique of prenatal testing. So the court said that discovery, the circulation of fetal DNA in maternal blood, is the discovery of a natural phenomenon. So the court continued, this claims, they are directed to a patent ineligible concept, because a method begins and ends with a natural phenomenon, because the claimed method do not transform the claimed naturally occurring phenomenon into patent eligible application of the phenomenon. So what's that application? Researchers, they already knew how to take blood, amplify DNA, and detect characteristics. This is routine knowledge, they said. So the particular application is the routine nature of the application does not transform the natural phenomenon into eligible subject matter. So at the CAFKI, they had to agree. They said, unfortunately, we have to apply Mayo. So we have to divorce the additional steps from the asserted natural phenomenon and arrive at the conclusion that they add nothing innovative to the process. And very importantly, the court said that the breakthrough nature of the discovery is irrelevant insofar as patent eligible subject matter is concerned. And I will come back to this last point in a minute. So the Sequanom site Chakrabarty, famous decision, I'm sure most of you know about it, so I won't say much, but in this Chakrabarty, it was a 1948 decision, Funk Brothers, and the quality, in this decision the court said that the quality, it concerned a mix of bacteria, so, and whether the qualities of this bacteria can be patented. So the court said the qualities of this bacteria, like the heat of the sun, electricity, the quality of metals, are part of the storehouse of knowledge of all men. They are manifestations of laws of nature, free to all men and reserved exclusively to none. So we see the idea that there is a sort of a public library packed with manifestations of natural laws, which is very importantly marked by open access. So these decisions have been criticized from various directions, as you could imagine. So industry and the legal profession, of course, they hate it. So they say that it conflates the scope of protection, right, eligibility with patentability requirements. It creates uncertainty. It discards, that's an interesting argument, that it discards the human intervention required in initiating the processes described. In Mayo, for example, a physician had to administer the drug, someone had to measure metabolites. Okay, so there is a lot of human intervention, one would, some argued. So the American Medical Association, they said that this is a decision, that this is a win for public health, because patents, they raise healthcare costs, and patents they shouldn't be allowed for this reason. But I want to say this, that although this is a very important argument, and we will talk about this argument later today, these decisions, they do not raise distributive justice concerns. It's not in the language of the court, at least. So indirectly, the debate concerning healthcare, maybe it has influenced the court, but it was not in the language used by the court. So that's one important point. So the decisions, they said something very different. They said that there is a realm of ideas that is open to all and from which individuals can freely appropriate to create technologies. This is a very different idea. So this idea has been criticized by philosophers of science, for example. This is an arcane view of science. What's this? It's a cosmos packed with manifestations. This is very old-fashioned. So we all know about this, ideas about social construction of science and what counts as science are familiar to everybody in this audience. So don't need to say more about this line of criticism. So another line of criticism comes from law people. So say that research property right and violating the justice. Why not recognize a research property right in these sort of discoveries anyway? So because we violate justice principle of treating likes alike. So there's a lot of labor theory informing this line of argument. So if you go back and Simon, so if you go back in the First World War, for example, you would see that there was a debate in Europe about research property rights that would cover basic research. So this line, there is a certain artificiality between this line, basic research, applied research, which products are patentable and which are not. So one could argue that basic research and discoveries, and breakthrough discoveries, for example, like the cfDNA, cell-free field DNA, they should be protected. And others now advocate in favor of a pragmatic, policy-driven approach based on the idea of a patent, that the patent functions as a trade tool. So let me talk about this the commercialization patent idea Seelman published and colleagues published on this idea. So he is, as you may know, he is the author. He has been cited by the Supreme Court, so it's important to read Seelman. And so he says, he's published a lot on the idea of commercialization patents. So patents should encourage cumulative innovation, like the court said. So he is in agreement with the Supreme Court in this respect. Patents, they should encourage cumulative innovation and further societal norms regarding access to knowledge by preventing patentees from claiming broad ownership over fields of exploration rather than specific applications of those fields. We're not that far from what the court said, if you read carefully this language. But they go on and say, but we have a different test. So for those, if there is someone familiar with the language used by management scholars, they use this kind of test. The claimed invention, is it likely to be generative of future innovation? Is the industry of concern relies heavily on cumulative innovation? Is it fast moving? Is it likely that the value of innovation is going to dissipate or not? So has this patent disclosed a small number of embodiments? Is it an important contribution? So this is the kind of test that they propose the Supreme Court should follow to decide whether a natural product or method should be protected by patents or not. So basically it doesn't matter. Basically what they say is that this distinction between eligible and non-eligible subject matter is not helpful at all. What we need is these set of ideas to inform the analysis, which is very much based on how the patent functions in the marketplace. So it's a very pragmatic, policy-driven approach. So the three tests, if we could summarize, the first step approach that could be used to classify subject matter, that's on the basis of the labor used to create invention. If you go back to Chakrabarty, so there is human intervention, and so we see the idea of the romantic author, and at the extreme we can see the idea of property, research property rights. A second test, a second approach. So we see that there is a variety of approaches, a variety of tests that can be used. So the second approach is used to classify subject matter. It follows utilitarian, rational, pragmatic, policy-driven, as I said, concentrates on commercial value and preemption of innovation and incentives and commercialization patent, and of course the optimistic view of markets, as Shobita, I think, discussed yesterday. So I would like to zoom in the third test, the Emayu test. So the third approach focuses on whether or not there is an inventive concept somehow associated with the subject matter in question. So the concern again here is preemption. In the name of the products of nature doctrine and one of the ancient secrets of nature now disclosed, the building blocks of science, look at this language. So that the court is alluding to the dangers of granting a monopoly on a critical scientific concept, but affirms that their core feature is not their status as ancient secrets or original causes, but rather their functionality as tools of trade, the trade of scientific knowledge. So I think that the court the Supreme Court in these decisions, they very much stays within the rhetoric of patents as a tool of trade and trade of scientific knowledge and the importance of cumulative innovation. So in Mayo, claims to exclusive rights over the body's natural responses to illness and medical treatment are permitted to stand. The result will be a vast thicket of exclusive rights over the use of critical scientific data that must remain widely available if physicians are to provide sound medical care. So it was a lot of talk. This was a amicus brief for the American College of Medical Genetics, and they cite, yes? Oh, God. And they cited this, so they took very much into account the idea that these patents they create thickets which are very time-consuming and expensive to navigate. So that was there. You see, requiring potential users to conduct costly and time-consuming searches of existing patents, pending patent applications, requiring the negotiation of complex licensing arrangements. So about now sequenons, for example, patent. If we know that other commercial and institutions and universities, which was a patent. First, the law patent was University of Oxford, by the way. But anyway, there were Stanford University and other commercial institutions. They had similar patents in covering that type of technology. But the law patent, it would the claim number one was so broadly drafted that it would be all other patents, they would infringe it basically. So Cook-Diggins written extensively on this aspect. So patent thickets was really a preoccupation for the Supreme Court. So now, private. So what's this? So if we go back, I'm very interested in the language used, the public domain. Is it really an ungoverned space then, all these laws of nature? And I don't think so. So. Private property, it depends. What the court said, basically, is that private property depends on the existence of a commons or public domain of resources from which individuals can freely take and appropriate, which is a very Lockean idea, of course. So by making statistical correlations non-eligible subject matter, the court effectively made them res publicae, I argue, or property belonging to the public and open to the public by operation of law. So what's res publicae or public law? It's like public roadways and harbors and bridges and other lanes of transportation and communication. So I think that unpacking the language of the Supreme Court should lead us to this conclusion, that the court said not that it's laws that we unplug from a static universe. The court basically said that these patents, they create bottlenecks, and these needs to be addressed because these type of data, they function like public roadway, harbors and bridges and other lanes of transportation and communication. So lanes, Rose's work on Roman law and Saunders' work are familiar to some of you here. So lanes of communication are vulnerable to many possibilities for obstruction and bottlenecks. The larger the network, the more valuable it is for all participants. But, of course, this doesn't mean that they serve the rich and poor alike, as Rose reminds us that avenues of public transportation communication allow for free trade, but public roads and open system, at the same time, they make private property more valuable, of course. They enlarge markets. So this idea of res publicae, if you, is synergistic to private property. So it's not an ungoverned wild space. It's not a static cosmos waiting for and laws waiting to be unplugged. It's property, public property that is synergistic to private property that enlarges markets and make them more valuable. So this idea, so if we look at this third test, the Mayo test, through this lens, this idea of res publica, then it raises a distinctive set of concerns that need to be addressed. So, where am I? Okay, so egalitarian concerns, who is in better position to get advantage of lanes of communication and who is not. This is something that needs to be addressed. And we also need to think, okay, what is not private property? What is not private property doesn't mean that is non-property. Okay, so there are other ways, there are other forms of property like common property, public property that lie outside the realm of private property. So, okay, so now this is something I'm working on from now, and I really want your input. So, for example, I was thinking that, as I think some people from the audience mentioned yesterday, and I agree that diagnostics, the diagnostic companies are small companies, they're small startups. So these are the ones that cannot get a patent now, for example. But pharmaceutical companies, on the other hand, they can still get a patent for if companion diagnostics that we were discussing, so if it's linked to a drug, to a new use, or to a new drug or a new use of an old drug, you can still get a patent for this kind of invention. So that's one way to think about what I said about the distributive effects. So the other thing is that, and large pharmaceutical companies, they don't have the internal expertise to discover and then commercialize companion diagnostics. They need diagnostic companies. Okay, the R&D, they don't do that R&D internally. As we know, pharmaceutical companies, they partner with diagnostic companies. So another thing is that these decisions, they make information about drug targets pre-competitive. And what does that mean? Well, there is a big debate on what kind of information, what kind of data should be pre-competitive. So there is a debate on the competition, and for example, AstraZeneca, they're funding a project at the University of Cambridge, I think, and there's a lot of money there for this kind of sharing data project. So they say oftentimes you find a variant, you think it's unique, you wait a short time, someone else will publish on the same variant. It's very difficult to compete against the world in this space. It's best to share, for example. So yes, but not everybody, of course, agrees. Not all pharmaceutical companies agree with this position, of course. And journals, they strive to peer review whether variants are truly associated with disease and whether publishing reputable data. So sharing variant classifications through a centralized database, is one solution. But, okay, so they cannot get a patent, but they can still, that's the other preoccupation, they can still protect by trade secrets, of course. And that's something that is not addressed in this idea of res publica and this idea of lanes of communication. This is something that is not addressed, that the algorithms and the data sets, they can still be protected as as trade secrets and obstruct flows of information. So, another way now, so we said about res publica, but this is not the only way. Now, I said that it is, okay, there are distributive concerns that are raised, and the second point I wanted to discuss is that, okay, there is not such a thing as private property, non-property, there's private property and other forms of property, so res publica is one form of property, but also common property, for example. So we could think of genomics information as a natural resource and say, okay, that we ask companies, that's according to this rationale, according to this model of property, to which means that A license to mine natural resources carries reciprocal civic duties, so laboratories' right to mine the genome could be conditioned on sharing information, but of course this amounts to compulsory utilization of genomic data resources. But the point here is that this is a different way to conceptualize data as property. So, and of course, this idea can be coupled with market solutions that I'm sure others will discuss here today, like liability rules, so take now, pay later rules, so there is a fee for using, for commercial companies, for example, to use data. So there's a conclusions then. So patent-eligible subject matter, it shapes innovation. It's easy for technology companies to offer multiple tests, competition tests, reduce prices, increase access to tests, barriers to technological innovation. But who will fund the next generation of genetic tests? So this idea, if this was the idea behind the Supreme Court's decision to have a res publica synergistic to private property, of course, we need more, which is we need more policy interventions, like fund creation of big data sets, discovery and validation of correlations, development, incentivizing data set sharing, prizes for disclosure of algorithms. All these have been discussed extensively in the literature. So, and finally, we need to go beyond this idea of property or non-property. So there is more than private property. And eligible subject matter is about. And I think that it's useful to conceptualize eligible subject matter as what is private property and what belongs to some other category of property. And so eligible subject matter has to do with the nature of the resource, genetic information, in our case, which is, I think, fundamentally an ethical question, how society values the resource. Is it lanes of communication? Is it a natural resource? Well, this answer, it really depends on on social context. So there is not one answer to this question, and there is not one answer to what is eligible subject matter. It's fundamentally an ethical question. Skip the last point because it's. So thank you.